If you have a hearing scheduled in family law court, this video will provide you the guidance that you need to be fully prepared and confident. If you are in the middle of a family law matter and cannot agree on everything, it's possible that you will be in court for at least one issue for the judge to make some orders on. Many people are intimidated or even downright frightened at the idea of attending court and having to introduce evidence or testify. Do not let this be a factor in your family law case. Hello Divorce is here to help, and we can even help you prepare for your individual hearing. Let's start with the basics. On the day of your hearing, get there early. There's a lot of hurry up and wait in the court process. Sometimes the judge will do an initial roll call right at the time that the courtroom opens. Then later, your case will be called to actually hear the substance of it. Other times, the judge will call the case just to hear a status, like whether or not the two of you need more time to meet and confer and discuss the issues pertaining to the case, or whether or not you have an agreement or need an actual hearing, meaning need the judge to make an actual decision on an issue in controversy. Think about parking and think about a security line. In major cities, parking can be expensive, crowded, or even require a walk from the parking lot or parking structure to the courthouse. Always have cash and coins available for this occasion. Most courts have a security line with a metal detector or even an X-ray belt. This could add to your time to get into court. Also, many courts have local rules, and judges usually have preferences as to how they run their courts. If you can take the time off of work, it's a good idea to visit the courtroom ahead of time and get a sense for your judge's style and temperament. Most family law matters are handled in a public courtroom, and you are more than welcome to see how your judge runs his or her courtroom. Once you've made it to and through the courthouse, find where your courtroom is and check in with the clerk. You'll usually find an official-looking person, a sheriff or bailiff, to help you out. Do not be afraid to ask questions, except when the court is actually in session, meaning the judge is on the bench. Usually, courtrooms will list their daily dockets on what cases they expect to hear. Sometimes it's just outside the courtroom next to the door. Confirm that your case is on the list. If it isn't, and you are sure your case is in that room, do not panic. Simply tell the clerk your case has been omitted from the docket, and he or she will make note. I hope I do not have to make too fine a point to always be courteous to courthouse staff. They are there to help you, and like most people, will be willing to do more for someone who is polite rather than angry or frustrated with them. To that end, remember that the judge is the ultimate decision maker in your matter, and they are judging everyone in the courtroom from the minute they see it. Dress appropriately. Think Sunday best. If you are a guy, you probably don't need a suit and tie that might be a little bit too formal, but you can wear a blazer with a button-down shirt or a sweater and slacks. Either one of those options is great. No matter what you wear, make sure you feel comfortable and, to the extent possible, like yourself. You want to feel like you. Do not chew gum, do not wear hats, do not bring any food or drink into the courtroom, and always turn off your cell phone, not just on vibrate, completely off or silenced. You will also want to watch your facial expressions. I know this sounds like common sense, but I see so many people scrunch their face up or leer at the other party in the courtroom. The judge is watching everything you do and is learning about you along the way. If you are showing signs of anger in a child custody matter, for example, a judge can interpret this as you having little patience or no respect for your ex. These are assumptions that can go against you when you are requesting more time with your children. Once your case is called, you will be directed to a table in front of the judge. Always stand until and unless you are told to be seated. Usually, before the judge will instruct you to be seated, he or she will ask the clerk to swear you in. In other words, you will be asked to raise your hand and swear to tell the truth. Answer audibly, yes or I do. Unless you have an attorney with you, you will be alone at the table. You do have the option to bring a moral support person or team, and there will be plenty of non-litigants and non-attorneys in the galley. However, it's probably not a good idea to bring a new partner with you. While it's nice to have someone you love by your side, it can be antagonizing to your ex and make the day even more acrimonious. Also, under most circumstances, the judge will not allow you to bring anyone up to the table other than your attorney. It's possible that the judge will pass your case and ask that you and your ex meet and confer or speak directly with each other to see if you can come to any agreements. This is most common in custody matters, where you and your ex really know the children's schedules and needs best. In fact, if your ex is represented by an attorney but you are not, the opposing attorney may ask you if you want to, quote, meet and confer, end quote, or discuss your case to see if you can come to any agreements before the hearing starts. It's a good idea to meet and confer. 1, it's a requirement before a motion is heard. 2, the more inconsequential things you can agree on, the more time the judge will have to hear your input on things that feel truly meaningful to you. And 3, it's not a good idea to have a hearing start out with the opposing attorney telling the judge that you refuse to discuss the case. However, watch the time. If you need orders on that day and the other attorney is delaying and wasting time, go into the courtroom and sit and wait for the judge to call your case. Judges stop promptly at lunch breaks, and when the courtroom closes in the evening, usually at 4 or 4:30, you don't want to miss your opportunity to be heard. Make sure you are prepared with your best and worst case position. So, for example, if you are appearing for a child support hearing, bring a support calculation with you. You can meet with a lawyer ahead of time to print out some calculations, or if the facts of your case are straightforward, like you both share 50-50 custody and you both have W-2 wages, then you can try to do your own calculations on the Department of Child Support Services website. If you are in court on a child custody matter and have not yet been to mandatory mediation, or you do not have a private, out-of-court mediator, then you may be sent to mediation with a therapist on that day. This is mediation only for you and your ex. No attorneys will be present. However, this doesn't mean you shouldn't be prepared. Mediators like when a parent is prepared. If you have a schedule that you think is in the best interests of your children, be prepared to explain why, and bring 3 copies, 1 for you, your ex, and a 3rd for the mediator, of an easy-to-understand, well-formatted calendar with your proposed schedule. Sometimes mediators will use this as a starting point. Do not interrupt the mediator or your ex. Mediators are looking for parents who respect the other parent and are more likely to be cooperative and co-parent effectively with the other parent. If you are unable to reach an agreement, in some counties, the mediators will make recommendations to the court as to his or her opinion of what makes the most sense for your children. Depending on where you live, these recommendations may be persuasive to your judge. You still may argue against them if you do not agree to them. If you want a court reporter, that is, someone who takes down all of the words spoken on the record, meaning in front of the judge, including what the judge has to say, then you should find out in advance if there will be one provided by the court. If not, they are available for private hire. If you feel this case may proceed to an appeal or that there may be a fight about what the judge in fact ordered, you will need a record of the proceedings. So it's a good idea to ensure a court reporter is present so that you can later review the transcripts, especially since it's very rare that you leave the courthouse with an actual enforceable order in hand. The reminder I gave you earlier about being nice to the courthouse staff goes double for when you're communicating with the judge. Judges do not take kindly to anyone with an attitude. Do not interrupt a judge, ever. They remember you, and they talk, which means even if your case gets moved to another courtroom in the same courthouse down the line, chances are, if you've made a bad impression on the judge, they will share it with their colleagues or it's in their notes. And while it might be easy to interrupt opposing counsel or the party, it will come across to the judge as more respectful if you let them have your say, even if you think they are lying out of their ears. And then ask the judge kindly if you can respond. Talk only to the judge, not to your opponent. Avoid arguing directly with them at all costs. Judges may ask questions, and they are truly looking for an answer to that question. Before going off on another tangent or making your point on another issue, answer the judge's specific question. If it is a yes or no question, answer yes or no. Most judges will ask if there is anything else you would like to share before they make their ruling. If they don't, and you are sensing the judge is about to make a decision, you may say something like, "Your Honor, if I may, I'd like to respond to Ms. Smith or Mr. Jones' statements." Or, "Your Honor, if possible, I would like to briefly expand on my pleadings or make a few more points for you to consider." Remember, your pleadings are the documents that you submitted to the court. After both sides submit their case, the judge will usually make orders. Usually, the judge assigns one of you to prepare the order. If you are preparing it, you will draft the court's orders and allow your ex to review and sign it before you send it to the court for the judge's signature and filing. If your ex drafts the order, it will be your job to make sure what he or she wrote conforms to what the judge actually ordered. Note, when you review the order, you are looking to ensure that the order is accurate. If you would disagree with the actual terms of the order, you may have an opportunity to request that the court reconsider the orders, or appeal the order, or modify it later down the road. However, the order itself from your hearing must reflect the actual terms recited on the record, meaning spoken by the judge to both of you. Please note that the orders are crucial and are often some of the most complex documents to draft. You can request the court reporter to draft a transcript of the rendition for you to refer to later and bring it to a lawyer to either draft the order or review it with the rendition to make sure that the order drafted by the other party is accurate. The actual hearing can be confusing and intimidating for most litigants. Hello Divorce can coach you. We can help you develop a strategy, how to ask the right questions, and even prepare and teach you how to get evidence introduced. Regardless, do your best to prepare. Bring copies of everything you want to introduce to the court, one for the judge, one for the other party, and one for you to refer to. If you plan to provide the court with any documents or photographs, make sure to provide it to the other party or attorney, if he or she is represented by one, ahead of time. If you plan on having witnesses, make another copy for the witness to review as necessary. Bring a notebook so you can make notes about things the other party is arguing or questions you might want to ask later, and so you can accurately write down the judge's order. Remember, take care of yourself.